Hello and welcome to The Big Fight. It's been the murder case that has captured the attention of this nation now for more than 5 years. The murder of Aarushi and what has happened this week, the conviction of her parents, Rajesh and Nupur, and their sentencing to life in prison. There are, of course, a large number of questions that go beyond the specifics of this case. Can you and should you convict somebody on the basis of circumstantial evidence? What is the level at which that circumstantial evidence should go? Where should the burden of proof come? And specifically, I guess, in this case, has there been at all a miscarriage of justice, or has this been one of the most shocking crimes ever? It has to be one of them. If the parents did it, it's a shocking crime. If the parents didn't do it, then there's been a miscarriage of justice. So we have a great panel joining us to take us through all aspects of this. I'm going to start off by welcoming Maxwell Pereira, former Joint Commissioner of the Delhi Police. Dr. Vandana Talwar, family member, has been for a long time talking and speaking about the fact that there has been a miscarriage of justice. And this week, I presume you've been really disturbed by what has happened and the verdict that's come. Justice R.S. Sodhi, former judge of the High Court, one of the most respected judicial minds that I can think of. So it's a privilege, sir, to have you with us. We also have with us senior advocate Rebecca John, who's done a lot of work in this particular case. D.R. Karthikeyan, who's a former director of the CBI. The CBI's role in this has, of course, come under substantial question for a while. Amba Sarakar is a fellow at the Inclusive Planet Center for Disability Law and Policy on some of the legal aspects of all of this. N.K. Singh is the General Secretary of the Broadcast Editors Association, who may answer some of the charges that have been made about a media trial and whether that had a bearing in this case and other cases like this. And finally, Satyaketu Singh, who's an advocate for the Talwars. So, Satyaketu, thank you as well for joining us. Dr. Talwar, your reaction after what's happened this week, and now whatever happens, they are going to be appealing, but they are going to be spending a substantial amount of time in prison while their appeal is heard.
I think, unfortunately, we were leveled against an organization which believed in manipulating and fabricating evidence. It believed in suppressing and hiding all the facts which shows the parents to be innocent. So conviction today has been given on the basis of circumstantial evidence, which too is cooked up. There is no golf club theory. There is no dressing up of the scene theory. And there is no such theory that outsiders could not enter. Maybe there may be no forcible entry, but there could very well have been a friendly entry. So today, what do we have? We have a motive which is speculative. We have a murder weapon which is again speculative. And we have no evidence. So they are being convicted for all those points which the CBI themselves said had circumstantial gaps, and they had actually filed a closure report.
Okay, Maxwell, at the end of the day, do you think the right verdict was delivered?
I would like to believe. I believe our justice system, and the judge has given a chronological sequence of the connections that, according to him, the merited conviction.
Okay, so you're saying that yes, they were guilty. Justice Sodhi, let me get you in now. If you were the judge, what would you have done? I mean, it's an unfair question to ask, I guess, because you're not the judge in that case. But at the end of the day, the sort of decisions that are taken and the balance of, in a case like this, which is largely based on circumstantial evidence, what should a judge do?
See, in a circumstantial evidence case, the judge must take care to see that it is not just suspicion itself, but more than suspicion, it's the fact, proven fact. Now, in this case, in all likelihood, since everything was circumstantial, the judge must have with great care ensured that no circumstance was left half-baked, or he was not relying upon a half-baked circumstance, or he was not giving far too much importance to what he thought was the case rather than what is the case. I think this would have been done, and if this were done, this is a good judgment.
It's a good judgment.
If the case had been judged based on the facts and evidence, there is no question of Rajesh and Nupur being behind bars today. I'm 100% certain of that. Then what is it based on? Is it based on the extreme prejudice which was created by maybe certain sections of the media, maybe by the insinuations which were off and on thrown in, first by the UP police and later corroborated by the CBI. So that kept on. So maybe it's the 100% prejudice which was there. Minds were already made up. So today I ask, where was the need of a trial? If minds were already made up, and I think maybe somewhere down the line, if I may say so, maybe it's the prestige of the investigating agency. It has to be maintained by them. And if two people are made scapegoats, well then too bad. That's how it is.
Mr. Karthikeyan, how do you respond to what Dr. Talwar has just said?
No, I don't think it's fair to make an allegation like that, because the CBI themselves were not charge sheeting the case. If you recall, the closure report was filed. The CBI wanted to close the case. But on the day the closure report was filed, I was asked on the television, what is it you would have done if you had been Director CBI? But before that, I had spoken to the then Director CBI, who wanted the investigating officer and supervising officer to speak to me. And on the basis of what was in the closure report as reported in the press, I told the then Director CBI, and same thing I told the anchor also on the television, the closure report itself gives enough facts to justify they are being charge sheeted for destruction or removal of evidence. I said I would have charge sheeted them for destruction of evidence. Yes. On the facts produced by the CBI in the closure report. But the judge, after a few weeks' time, he converted. He said, no, there is enough material to charge them, to make them stand for trial for both murder and destruction of evidence.
So are you saying that you think there was only enough evidence for destruction of
that had taken place?
So, Mr. Karthikeyan, can I just ask you, are you saying that when you looked at it, the evidence is only enough for destruction of evidence and not for murder? Is that what you're saying?
Going by the judgment, not only that daughter has been killed for maybe a sudden provocation or whatever it is, I don't know, I have not read the judgment, but the subsequent act on their part has been proved in the evidence, that is trying to cover up that and also filing a false report. See, that has aggravated the situation. If it had just been an act on a sudden provocation, perhaps the charge sheet would have been for something less than murder, culpable homicide not amounting to murder.
Okay.
And perhaps they would have got a lighter punishment also. But the point is, not only the parents lost the daughter and the servant boy, the family of the servant boy, but the thing is, it is the society which is aggrieved. It is the offense. It's against the society. So society needs justice. Who killed the girl?